And who?
Morning, Judge. Torshio Feaster, first assistant public defender. We likewise do not believe that any waivers exist, any conflicts exist in this matter, but should.
Edward Drucas on behalf of Chad Jones in 2196.
Stephanie Cannon,
Really?
yes, Your Honor. On behalf of Mr. Jones, as to all other matters, you only have 2196, right? And Your Honor, I reached out to the facility. Oh, you got it?
I had reached out. We can set up a conversation with him. After the last appearance, our office submitted a plea form along with a police report. I have an advice of rights with me right now. The court in receipt police report. I do not have any of the accompanying documents. Okay, Your Honor, I have a plea form. Would the court consider a no contest plea today, or would the court prefer we adjourn this? Well, usually I don't review the police report. We're off to a good start. Your Honor, can I provide the court with that plea form? Apparently, you didn't hear what I just said, but that's okay. She's at. Yeah. Thank you, Your Honor. Court calls the case Feeble versus Tyler Cochran. Good morning.
Good morning, Your Honor. William Amadeus, P76. At this time, defense is going to waive their prelim if there's no objection from the defense. I'm working on a global resolution. I should say resolution circuit court.
So you're waiving your right to a preliminary examination? Yes, Your Honor. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. Defendant is bound over to circuit court on counts 1 through 5 with 6 following. Mr. Amadeus.
Your Honor, will waive a formal reading, stand mute, and ask for a pretrial date.
Guilty plea. Pretrial will be set for
July 28th at 1:30 with Judge Cummings.
July 28, 2026, 1:30. Let's call the case Feeble versus Cameron Hall.
During the bill from people, Your Honor. In Zilchin.
Sherilyn Foster Tucker on behalf of Cameron Hall. Mr. Hall, can you state your name?
Cameron Hall.
Got it. All right, I got it.
And Your Honor, we're requesting a preliminary exam in this matter, and if I may address bond briefly.
Discovery is complete.
To my knowledge.
What? Go. What date are we on?
21st.
People, this is available the 21st. Preliminary examination in person, July 21st, 2026, 9 a.m. before judge. As to bond.
Your Honor, I believe Mr. Hall's current bond in this case is $5,000 cash surety. He does have a case pending in front of Judge Barr, which should be resolved today. I believe he will be asking. He's
probably should have led with that, but go ahead.
Asking for the court to consider either a 10% or a nominal bond in case that case is resolved and he has a bond today.
At this point, I'm going to deny your motion. Changes bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case People versus Teagan Donnell. Now.
Morning, Your Honor. Raven Cook for the people.
Assistant Public Defender.
Teagan Donnell.
Your Honor, we're filing for competency in this matter. We would request an adjournment for that purpose.
Pardon?
We're filing for competency in this matter. You should have the form. We would request an adjournment for that purpose.
Forensic evaluation will be ordered. Competency hearing in this matter will be set for
October 8th.
October 8th, 2026, 9 a.m.
Ms. Donnell, you do have a right to speak. I would advise you not to, but that is your right.
Me completely, so I guess I have to represent myself.
You want to represent yourself?
I guess so, because he's literally declining to step forward on something that's completely blatant in the case that makes it non-valid.
Uh,
The 14-day rule is a literal law that you cannot, if you're not arraigned, or it has been almost 90 days and you've not
All
done
right.
anything in this case whatsoever. And he tried to make me think
90
I did for
days.
some reason.
It's been 90 days since when,
No
man?
arraignment.
Your Honor, may we approach?
Pardon?
Your Honor, may we approach? I may be able to.
May. All right, record should reflect we've had a bench conference in this case. Mr. Bell, what I'm going to indicate is I'm going to leave this set for a competency evaluation. Hear it. All right, thank you.
I don't have a lawyer that, but this case is almost over. This actual case is almost over. That being said, you have not done anything within 90 days. You can't just randomly do or take legal action,
Ma'am,
70 days later.
Ma'am, I
Yes, sir.
realize you're trying to tell me with your law degree what I should do. I just told you what I will do. That is how we're going to handle it.
Repeat?
You do have. I would say the same, but not. Court calls the case, People versus Xavier Bonner.
Morning, Your Honor. Raven Cook for the people.
Should be Mr. Amadeus. Oh, it's Mr. Amadeus.
Where is he? He was all up in here.
Morning, Honor. William Amadeus, 76194. We have a Xavier Bonner. Xavier, please state.
Bonner.
Judge, I just got an accurate phone number from Mr. Bonner. I took over the case about a week ago. I'd asked for a 2-week adjournment. Communicate with him. I do believe there might be discovery coming from Prosecutor Cook.
That objection, July 23rd, 2026, 9 a.m. Bond continues.
Thank you, Judge.
Court calls case of the People versus Sky, Preven Jones.
Morning, Your Honor. Raven Cook for the people.
Good morning, Your Honor. Jay Grant Miller. We're going to request a chambers conference, Your Honor.
Chambers conference?
Yes, Your Honor.
Want me to stop in the middle of everything right now?
I apologize. I hadn't spoken to Ann this morning, but I had indicated it to the other clerk. I didn't expect to be called. I apologize, Your Honor.
I'm not gonna.
Referral for competency.
Do I have an order?
I have not prepared one, Your Honor. I've been working all morning.
Forensic evaluation is ordered. Competency hearing will be set October or what? Buckner?
People, Your Honor.
I'll back it.
Why does he keep leaving? Just chaining the Goldstein.
Morning, Your Honor. William Amadeus, 76194 for Mr. Buckner. Eric, please state your name. Your Honor, we'll be waiving the prelim on this, working on a global resolution in the circuit court.
So you're waiving your right to a preliminary examination? Yes. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have that hearing, you'll proceed to circuit court for further resolution. People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 through 3 with 4 following.
We'll waive a formal reading, stand muteness for a pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to all charges. Pretrial in this matter will be set for
September 1:30 or Judge Hunky.
September 1st, 2026, 1:30.
Thank you, Judge.
No. No. Court calls the case People versus Jesse Hardman.
Morning, Your Honor. Edward Drupes on behalf of Jesse Hardman. This is a waiver, Your Honor.
Jesse Andrew Hardman?
You're waiving your right to a preliminary examination.
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed, the offenses alleged that were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Sure.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on counts 1 through 7 with 8 following. She's getting on my nerves. Court calls the case People versus Tarrant Hall.
Well, Terrence, please state your name for the court.
Tarrant Hall.
Your Honor, this time asking for a 2-week adjournment. I was put on this case about a week ago. I want to make sure I have all discovery and then we'll decide which way we're going to go if that's acceptable to the court.
This is Justin Heaton.
Ready to go. They are.
Robert O on behalf of Mr. Heaton. Justin, please state your name for the record. Justin Heaton.
Thank you.
Your Honor, may we approach?
Yes. Record should reflect we've had a bench. Court calls the case of the People versus Christina Eikert.
Morning, Your Honor. Public safety.
Good morning, Your Honor. Marsha Creature on behalf of Ms. Eikert.
Ms. Eikert, can you state your name, please?
Christina Eikert.
Thank you. He's waiving.
Yes, Your Honor.
Ma'am, you're waiving your right to a preliminary examination. Court just call the case People versus Lewis McSwain.
Ashley Phelps is for the vehicle.
I apologize. Unless you pass, he was here. He probably went to the bathroom.
What if I said no? You're walking away.
You're the boss. I'll say.
I know. Didn't act like it.
And I apologize.
Showed up. I knew he was here. Court calls the case of the People versus Josiah Miller.
On behalf of the defendant.
Your Honor, I heard what the court said earlier. I do think there's a conflict in this court. Ms. Feltus thinks my client is guilty and I don't.
There's always a conflict then.
State your name, Josiah.
Don Miller.
Your Honor, we're going to be waiving exam. My client has to sign the waiver form.
All right. So you're waiving your right to a preliminary. The people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been.
My client waives the reading of the information in this matter, Your Honor. My client stands mute, asked that a not guilty plea be entered.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
July 28th at 1:30 with Judge Humphrey.
July 28, 2026, 1:30.
All right, thank you, Your Honor.
Thank you. Bond continues. She's stalking. Court calls the case. People versus Lance Ford.
Your Honor,
Mr. Ford, state your name.
Lance Ford.
Your Honor,
Yes.
I've spoken to Mr. Ford. Your Honor, I've explained to my client that I don't have a full discovery. My client is adamant that we set this matter for an exam. I explained to him the normal course is for me to ask for a permit back in discovery, which I would have good cause to do. But Mr. Ford wants to set this matter for an exam.
Is that right, Mr. Ford? Even though your counsel is saying he doesn't have people have their witnesses available the 28th. Preliminary examination in person will be set for July 28th and 26th noon. I'm not going to entertain an adjournment or anything along those lines because you don't have discovery.
I 100%.
You'll just sleep in the bed that you want to lie in. Thank you. Bond continued.
Thank you, Your Honor.
Court calls the case. People versus David Sarpo.
And is that on behalf of the people?
Bond continued.
Thank you, Your Honor.
Court calls the case. People versus David Sarpo.
And is that on behalf of the people, Your Honor?
Good morning, Your Honor. William Amadeo, P76194 for Mr. Starpo, who will be coming up standing to my right. David, when you approach, please state your name for the court.
David Sarpo. Thank you.
Morning, Your Honor. My client and I met last night. He wants to proceed to a preliminary examination.
Discovery is complete.
Yes, sir.
People have their witnesses available the 21st.
Starbucks, Your Honor.
Preliminary examination in person will be set July 21st, 2026, 9 a.m. before Judge Barr. Bond will continue. Thank you. Court calls the case. People versus Deshawn Jones.
Vote for the people.
morning, Your Honor. Edward Lucas on behalf of Deshawn Jones.
Deshawn Jones. Thank you.
There's a green sheet in the file. We'll be asking for an adjournment. We're close to setting up that meeting that we've been working on.
9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court does call the case. People versus Davon Thompson. Counsel Simpson.
Your Honor, good afternoon. Maisha Games on behalf of Mr. Thompson.
Your name? Davon Thompson. Thank you. What are we doing?
Your Honor, we'd be requesting pursuing a preliminary exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the 21st. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case of the people versus Scott Kidney.
Those are the people, Your Honor.
Good morning, Judge Carpenter, on behalf of, but not with Mr. Kidney. May we approach?
Your Honor.
Yes. Record should reflect we had a bench conference in this case. Probable cause conference will be adjourned to July 28th, 2026, 9 a.m.
Thank you, Judge.
What are you two? Court calls the case, people versus Erin Burrows. Erin Burrows.
Thank you, Judge. According to the note file, this matter was supposed to be have a plea resolution, but we have not been able to get that completed and into court before today's date. We'd be asking for a brief adjournment to get the plea resolution into the court.
So you've already resolved it. You just have to get the paperwork in.
That's what the notes indicated, but I haven't talked to Ms. Dover about it.
Court calls case of the people versus Danielle Polgar. That's going to go better than the last one you had.
I'll do my best, Judge.
An adjournment in this case. And I don't have a green sheet for all of those when she went out into the hall.
I get
You threw her under the bus, didn't you?
Yeah.
Yes. I need two.
All right.
Know how much time you need?
2 weeks.
All right.
Can I get the phone?
Any objection from the people?
Honor, things went bad. I had to step away for a second.
Well, nice to have you back.
He was in the hospital. I actually went to visit him in the hospital. They said, you can't do that. Then I scheduled a Zoom meeting with you and they said, our bad, he got released. You can't Zoom with him. And now he's here. So I did speak to the lieutenant, Your Honor. And what I would like to do is adjourn today's date so I can talk to him about his matters. There's been an offer extended. But in addition, I'd like to address bond, Your Honor. My client is, I'm sorry, he has a lot of medical needs. He's been in and out of the hospital since he has been a part of the system. Your Honor, my client, we're asking that he be released. We want to put him on tether, home confinement. We would be fine with that as long as he has the ability to go to all the medical appointments that he has.
Objection is denied. Bond will continue.
Thank you.
I did it 3 times. It failed.
Thank you.
But not with, Your Honor. She was recently released from the mental health facility. When I spoke to her yesterday, she was going to come in, Your Honor. She is trying to get here. She doesn't have a vehicle, but she had recently been released from the mental health. Make sure she's getting here. I am dying. I don't know.
No, don't say that.
Please.
Okay. Oh, I'm going to set it. I'll pass it briefly.
Thank
a little bit of time to get her here.
I will.
Yeah. That's when you pass my case. I'm dying.
When I had where we need to get our our police report in for no contest plea, and we're not able to get that done before the deadline. So we're asking for an adjournment to be able to get that in.
Probable cause conference will be adjourned to July 16th, 2026, 9 a.m. Bond continued.
Thank you very much, Judge.
Everly.
And is that not okay? Your Honor.
Your Honor, Amy Lucas, requesting permission to practice under Michigan Court Rules 8.120 under the supervision of Assistant Public Prosecutor Jay Bellinger. We're looking to enter a plea today.
I have before me a plea form that indicates that the defendant will be pleading no contest to 3 charges.
That's my understanding.
Count 2 is domestic violence, a 93-day offense. Count 3, assault and battery, also a 93-day offense. Count 4, malicious destruction of personal property, 200 to 1,000, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. Defendant is agreeing to complete a substance abuse assessment and follow all recommendations, including inpatient treatment or outpatient treatment. The prosecutor and defendant are agreeing to a sentence agreement of sentencing for. Sir, it is this court's understanding you're going to plead no contest to 3 charges. First charge is the added count 2 of domestic violence, or actually stated count 2 of domestic violence. That's a misdemeanor punishable by up to 93 days in jail, a $500 fine plus court cost. 3 of assault and battery. That's also a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. Do you understand that?
Yes.
And also no contest to malicious destruction of personal property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property taken if that's greater than 2,000 or destroyed. You understand that, sir?
Yes.
Do you understand what a no contest plea is?
Yes.
2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes.
Second thing is that for purposes of, you understand that?
Yes, Your Honor.
You understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court.
Yes, Your Honor.
All right. Basis for the no contest plea?
Liability.
Sir, to the charge of domestic violence, how do you plead?
Guilty.
No contest.
No contest, I mean.
To the charge of assault and battery, how do you plead? Be signed on your behalf an advice of rights form, is that correct?
I think I did.
Well, did you?
Yes.
To the court.
All right. Do you have any questions regarding any of those rights?
No, Your Honor.
You understand that you're waiving or giving up all of those rights, including the rights under paragraph 5, which are your trial rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than?
Yes, Your Honor.
All right. Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 2637598. Any objection to the court having reviewed that report?
No.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Sir, I do have to advise you that if between the time I accept your pleas and the court will accept the defendant's plea of no contest to counts 2, 3, and 4, count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
July 30th at 9 a.m.
July 30th, 2026, 9 a.m. before Judge Barr. Court calls the case People versus Dontrell Smith. Thank you. What are we doing?
So, Your Honor, I don't think we have much that we can do today. We're waiting for a competency report. I did receive the letter from the Forensic Center indicating they were needing about a month. They still had some documentation that they needed to get.
All right. I'll adjourn the competency hearing then to August 3rd, 2026, 9 a.m. Bond will continue. Thank you, Mr. Smith. Court calls case People versus Robert Jameson II.
Brian Bowling on behalf of Mr. Jameson, Your Honor. Hey, morning. Can you state your name for the record, please?
Robert John Jameson II.
Your Honor, I'm asking for an adjournment of this matter. It's my understanding that Mr. Jameson was referred for screening for the Circuit Court Recovery Court in another matter. If you want, sorry.
It's screened already, or that'll work? All right. Probable cause conference will be adjourned to July 28th, 2026, 9 a.m.
Thank you, Judge. Yep.
Thank you.
Thanks, Judge.
Court does call the case. People versus Angelina Bonacera.
I was informed by Washtenaw County Jail staff that last evening Ms. Bonacera was transferred to Monroe County Jail. Are they on Zoom?
So she's been transferred?
Yeah, last evening, I think, ex-jail says around 4:30.
All right. Did they say is she coming back, or we reflect we've got a bench conference in this case? I will adjourn the probable cause conference to.
And I am just asking for an adjournment on this matter. I've talked to Ms. Dover about this case. It sounds like we're both on the same page with regard to our ask for a release to inpatient treatment, contingent, and that would be contingent upon his successful completion. 3 weeks would be more appropriate, Your Honor. I can get the paperwork in today.
I don't quite have 3.
That's right.
28th.
The 28th would be fine.
All right. I'll adjourn it to July 28th, 2026, 9 a.m.
This case, we just need to finalize the paperwork.
Adjourn probable cause to July 23rd, 2026, 9 a.m.
Perfect. Thank you, Judge.
Thank you.
Your Honor, I've completed a green sheet. We are requesting an adjournment. I believe that
2026, 9 a.m. That's a Tuesday. Bond continues.
Thank you, Your Honor.
Thank you. Court calls case People versus DeAnthony.
Given that he violated his bond, I'm going to be asking for him to be remanded and that his phone privileges while in custody be revoked.
Mr. Allen, please.
And Your Honor, Ms. Zenda relayed that, and I can't corroborate that at this point, Your Honor, and I'd ask to come back on the 16th when I've had the ability to do that. What I would ask the court to consider, Your Honor, is that Mr. Buford's 27 years old. I don't believe he has any criminal history, and see that he has 2 open pending traffic matters, but certainly nothing assaultive or felonious. Apart from the complainant, part of the bond that was set in this case involved a hot zone tether, and I think subsequent to his release, I don't believe there have been any additional allegations of misconduct while on bond. So I'd ask the court to consider continuing his bond at this time pending a hearing on the 16th, Your Honor, or a probable cause conference on the 16th.
My understanding is you have them post-arraignment.
Correct, Your
Adjourn to the 16th, 2026, 9 a.m. Defendant, he's not really admitting to the violations because you don't have the timing other than what the people have indicated, but they given the court enough. Defendant's bond at this time is revoked. Defendant's demanded. I'm also revoking his phone privilege. He has that includes texting.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case People versus Lee Pat.
And then on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Patton.
Leandre Patton.
Thank you.
Your Honor, my understanding is Mr. Patton wishes to waive his right to a preliminary examination waiver form before me. And I believe people have indicated upon his waiver they will not be seeking any habitual offender sentencing enhancements in this case.
So you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by the standard of probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution. People also waive their right. Preliminary examination, having been waived, defendant is bound over to circuit at
1:30 with Judge Moon.
July 20th, 2026, 1:30 for Judge Hamoud. Bond will continue.
Thank you, Your Honor.
But not with Mr. Butler. There seems.
All right. And court will let you defendant's failure to appear bond is setting him at 10,000. Okay.
All right.
Yeah, get rid of it. Yeah. Nice try, Will.
Got that.
Yeah. Court calls the case, People versus Davon Reed. You learn anything?
Ashley Jones for the.
Oh, what'd you learn? There we go. Yes.
Amy Lucas on behalf of the state, Your Honor.
Ari. No, you're not.
Not really, no.
Whoa, really? Wow. I don't know. I didn't think that tiger had earned them stripes yet, but I no, she meant it. She meant it. You know the reason I know she meant it? Because she's normally very nice and everything, but then Cannon got it right. Okay, go ahead.
Your Honor,
You're good. Don't worry about it. They're in trouble.
We'll try for that today.
All right. Preliminary examination will be set July 21st, 2026, 9 a.m. in person before
Judge Moore.
Judge Moore. People have any objection to release the treatment?
Yes, Your Honor.
Position, I'm going to, you submit an order to the court, consistent with the circuit court's order. I'll allow release to Bear River.
Thank you, Your Honor.
All right. Thank you.
Your Honor.
Gates, the defendant will be pleading to an added count 2 of what? Oh, an attempt embezzlement, 200 to 1,000. That'd be a no contest plea. That's a 6-month. Bonner plea to that charge, count 1 would be dismissed. Defendant is agreeing to pay full restitution.
That is my correct understanding of the offer, Your Honor, as well as my client's.
That's correct, Your Honor.
Attempt embezzlement?
Yes, Your Honor.
There's a reason for it.
2 were involved in this.
Yes, Your Honor.
Okay. All right. I get it.
That's how you know you can trust.
This court's understanding that you're going to be pleading no contest to the charge of attempted embezzlement, 200 to 1,000. That is a misdemeanor punishable by up to 6 months incarceration, a $1,000 fine plus court costs. Fine could be increased if that would become the maximum fine. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
2 things about it I have to make sure you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. Contest plea?
Potential civil liability, Your Honor.
Right. Ma'am, to the charge of attempted embezzlement.
No, Your Honor.
You understand that you're waiving or giving up the rights contained on that form, including the rights contained under paragraph 5, those being trial rights.
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
July 31st at 8:30.
July 31st, 2026, 8:30 before Judge Perry. Bond will continue. Thank you, ma'am.
Thank you, Your Honor.
Ma'am.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case People versus Akim Sanders. Thank you. Court calls the case People versus Canteria Cummings.
Thank you, Your Honor.
Thank you. Court calls case People versus John Smith III. She said, move. She's yelling at me. She is. She's screaming.
And Alex Warren Green on behalf of Mr. Smith III. Mr. Smith, can you state your name for the court?
Court calls the case, People versus Jerry Doss.
Morning, Your Honor. Raymond Cook for the people.
Court does call the case, People versus Jason Szymanski. Court calls the case, People versus Robert Burrows.
I don't know where that is.
Okay.
But it appears that I do know what his destination facility is. I've emailed opposing counsel in the court. I would request an adjournment, extradited him to that jurisdiction. If that makes any difference.
Fine job they've done. I mean, I don't know what.
I see.
What am I supposed to take from that?
Sorry. Yeah.
All right, thank you. Court calls the case, People versus Justin.
Raj, please state your name for the record.
Justin Tasher.
Thank you, sir.
We go to waive circuit court.
Thank you, Judge. Mr. Taft is executing the examination waiver. We tender that signed paperwork to the court.
Sir, you're waiving your right to a preliminary examination?
Sir.
You understand that that's a proceeding where the people have to show by probable cause that the offense alleged was committed in.
Yes, sir.
You understand you won't have that here. You'll proceed to circuit court for further resolution.
Sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count.
Thank you, Judge. He'll waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 20th at 1:30 with Judge Hamuth.
July 20th, 2026, 1:30, Judge Hamuth.
Thank you.
Court does call the case of People versus Juanita Glaspie.
Assistant Public Defender Jay Bonner on behalf of Ms. Glaspie, who appears via Zoom. Ms. Glaspie, can you please state your name for the record?
Juanita Glaspie.
Had before me a form indicates that the defendant will be pleading guilty to the charge of retail fraud second, the 1-year offense. Upon our successful plea to that charge, retail fraud first will be dismissed. That's the court's full understanding of the agreement. Ma'am, can you raise your right hand, please?
Yes, Your Honor.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, state your name for me.
Juanita Glaspie.
All right. Ma'am, it is this court's understanding you are going to be pleading guilty to the charge of retail fraud second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. And understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Guilty of this offense?
Yes.
On April 27, 2026, at the location of 7,000 East Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, what did you do at the Walmart that makes you think that you're guilty?
Walked out with their merchant, but they got their merchant back.
Value, I believe.
Okay. And ma'am, was the total value of the property that you tried to walk out for, was that in excess of $200?
Yes.
Okay. Ma'am, I do have to advise you that between the court will accept the defendant's plea to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be. Bond will continue. Ma'am, thank you.
Thank you.
Court does call the case, Feeble versus Stephen Huska.
Oh.
How long has she been there? An hour? No, she never ships up better. No, I got the lilies mixed up.
Your Honor, I can attest to the fact that that is my client. We have met with each other before.
Okay. All right, what are we doing?
Your Honor, we're going to go ahead and set his case for a preliminary exam. There's no forthcoming at this level.
All right, where is he?
He is in
County?
Huron County Jail.
All right. Discovery is complete.
Yes, Your Honor. Thank you so much, Your Honor.
All right, thank you. Court calls the case, the people versus Quintez Tomlin. Want the 28th or August 6th?
I think August 6th would be appropriate.
All right. Probable cause conference during August 6th, 2026. Bond continued.
Thank you very much, Your Honor.
Little
All
more.
right, Mr.
Oh, she yelled at me and then I had to do something different. Whole thing got messed up. I don't know what happened. What? I mean, yes.
Assistant Public Defender Zach Vinny with and on behalf of Ms. Greer, who is present via Zoom. Ms. Greer, please state your name for the record.
Zaya Greer.
All right, I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of malicious destruction of personal property, 200 to 1,000 to 1 year. Upon a successful plea to that charge, count one would be dismissed. There is not. It just says defendant is seeking prosecutors deferred. That will be determined at sentencing.
That's correct, Your Honor. So it's not an agreement, but it's just put on there.
Put on there for the purpose. Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
State your name again for the record, please.
Zaya Greer.
All right, you can put your hand down. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of malicious destruction of personal property, 200 to 1,000. That is a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property destroyed. If that's greater than 2,000, that becomes the maximum fine. You understand that?
Yes.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
I plead guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed or had cause to have signed an advice of rights form. Do you have any questions regarding any of those rights?
No.
You understand that you're waiving all of those rights, including the rights contained under paragraph 5, which are your trial rights.
Yes, I do.
You understand you're giving up your right to appeal and because you believe that you're guilty of this offense?
Yes.
July 4th, 2025, at the location of 1308 Jones Street. What'd you do on that date that makes you think that you're guilty?
I hit my cousin's car with my car.
Okay. Nothing like close family. You did that on purpose?
I did.
All right. Was it in excess of $200 worth of damage?
I believe so.
What were you driving? Like that the amount of damage is in excess of $200.
We would, Your Honor.
Yes, Your Honor.
All right. Ma'am, I do have to advise you between the time of my acceptance of your plea and the time of sentencing, that if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand? Will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing will be. Court calls the case, Feeble versus Keith Wadley.
Thank you, Judge. My understanding is Mr. Wiley would like to set this matter for preliminary examination.
Court calls the case of the People versus Hunter Hallis.
Assistant Public Defender Zach Vinny. Your Honor, Mr. Hallis.
Have long pants?
Mr. Hallis apologizes for his appearance in court today. I did forget to warn him to not wear shorts. That's my fault. Your Honor, we're requesting an adjournment.
On purpose.
No, I promise.
He promises, Your Honor. Your Honor, we're seeking an adjournment. We're waiting on some video from the people.
And if I give him the adjournment, he'll be properly attired when he comes back?
He will, Your Honor. I'll make sure of it.
How much time did you need? 2 weeks?
As Your Honor, I got the video and it's being.
We get the French. No. Court calls the case. People versus Benleo Winter.
Ready to judge. Senator, on behalf of Ms. Winter, who is approaching. Ms. Winter, when you arrive, please state your name for the record.
Leah Winter.
Thank you, Judge. She spoke with my intern at the jail the other day. My understanding is we're still working on trying to reach a resolution. If we can have a brief adjournment, we'll continue to get this matter resolved.
July 23rd, 2026, 9 a.m. Bond continued. Thank you.
I'll send more. In speaking to my client, it sounds like she has indicated that she will return to court should the court allow her an opportunity for a bond, not resources financially to be able to post the current bond. He's asking the court might consider a PR bond or a 10% bond, at which point I hope she could post that and she would return for all future court dates.
I've got nobody tomorrow. I was under the impression he gave me a PR already 2 weeks ago.
Judge Simpson did?
Yes. Then you.
What?
She says she's under the impression you may have already given her a PR bond on this file 2 weeks ago. Is that what your file reflects?
You did. You told me to show up to court and you did offer me a personal recognizance. I got my holds taken care of and I've been in custody ever.
Oh, slow down.
Sorry.
You're going too fast. Say it again.
I said, it's in the file.
Going too fast for him.
Sorry.
Go ahead.
I said that, last time I seen you, you offered me a personal recognizance, had my holds be taken care of. They did. Nobody expects me in person tomorrow. And, we've been under the impression that I had a PR.
She was moving too fast for me, Judge. What I think I heard her say is that 2 weeks ago, you told her that if she got all her holds and other counties cleared, then the court would entertain the possibility of a PR bond.
That sounds like something I would say. I don't.
That's all those holds are now cleared. Thank you.
But okay, so in the interim, she's gotten her holds cleared up.
Correct, Your Honor. She says she does have a court date tomorrow in Novi, and she is supposed to be there in person. So she requested the court allow her a release.
Got it. Do the people see that?
I'm double checking actually right now, Your Honor. I think part of the concern was there was a missed court date and defendant indicated.
Remembered that.
Yes,
I think she said it's a mandatory hotel, Your Honor.
Oh.
You have an address to say with
I don't know why what was it? What's in South Dakota?
my mother. She just had surgery on this.
Oh, okay.
But I'm not leaving. I have a place to live in Adrian with my uncle, her youngest brother, Joseph Hunt.
I see 2 holds out of the next jail. One Novi and one MSP.
And
So
we don't need anything.
So Fisher has been they're wasting my time.
I took
yes, ICR, but they never got it.
They're wasting my time, and then Agnes Burley joined in, wasting my time. I could have been done with the whole docket by now. I thought I had given her that.
I owe you 5 minutes, Judge. I'm sorry.
Got a bad dispo. I mean, I weeks of my time.
What do I tell ITR? Have no clue.
Welding is gonna.
We will make sure.
Okay, thank God, because I missed my mom's surgery and
It's down indicating that your bond here is a PR. I think that the only thing that may need to follow is that Judge Washington's bond, that somebody
I'll reach out.
lets them know.
Yes, Judge.
thank you.
Court does call the case People versus Robin Hart.
Your Honor, the court did not grant my request for a stipulated adjournment in this matter. I was not in office for 2 days and she was trying to reach me. And so when I spoke with her yesterday, the prosecutor and I did
So this is my fault?
No, 100% mine for taking time off. And it's my fault, but she literally had to choose between losing her job or court, Your Honor. I'm just asking for a 1 week adjournment. She has somebody covering her shift next week. She will be here. She's been here for every other court appearance. Please, Your Honor. You might remember she came out the building because she was in the building And it was like she couldn't, it was static. And so she came outside and she got reprimanded when she went back inside. And they were like, if you do this again, you're gonna lose your job. Okay. Please, please, it's just a. It's totally my fault.
Adjourn the matter to 16,
Thank you, Your Honor.
2026, 9 a.m.
Thank you. Ian, you're supposed to be on my side.
Close the case, Feeble versus Dean Hodder. So.
Assistant Public Defender Zach Venue on behalf of Mr. Hodder, who could be present via Zoom.
It's right there. Everybody knows Mr. Hodder because there's shorts in here. Did you not tell any of your clients about proper dress etiquette?
Your Honor, Mr.
This one over here. I need a taser. Court does call the case. Feeble versus Tyree Hayes. She muted again.
Okay, good job. Now
I'm
state your name.
trying to unmute it. My phone is being crazy. Can you hear me?
You're fine. Yeah, we can hear you now. Go ahead and say your name.
Tara Hayes.
Your Honor, we're asking that this be set for a preliminary exam.
And good morning, Your Honor, Assistant Public Defender, really on behalf of Anderson, who is approaching. Mr. Anderson, come on up, Sean. Say your name for the record, please. Evans.
You have all discovery.
Yes, Judge, to our knowledge.
Were other witnesses available the 21st? Thank you.
Okay.
On. Court calls the case Feeble versus Marcus Hopkins. Thank you.
Thank you, Judge. Mr. Hopkins, and I just established contact for a brief adjournment so that we can have more discussion about this matter and determine next steps.
Court calls the case Feeble versus Curtis Jackson.
Full name for the record. Oh, he's not on there?
Not on here.
Oh, Your Honor, I'd request.
Was he on here? I'll pass it. Tell him find some stable Wi-Fi. I'll call it later.
Thank you, Your Honor.
Court calls the case Feeble versus Eric Jackson.
Thank you, Your Honor. Alex Warren Green on behalf of Ms.
Court calls the case Feeble versus Eric Jackson.
Thank you, Your Honor. Alex Warren Green on behalf of Ms.
Thank you.
Your Honor, I'm asking the court to adjourn this matter. We're working on mitigation, and after we complete that, we're going to approach the people and ask for, could the court accommodate a 3-week adjournment?
Court calls the case Feeble versus Jennifer Jackson. Are we done with in custody? Thank you. Yeah. What price?
Today. Yep.
Oh, that's right.
Yeah.
It is. Like a blind squirrel finding a nut. Don't know.
Asking for an adjournment, Your Honor.
Court calls the case of the people versus Jerry Jackson.
Judge, I'm asking for an adjournment. I'd like to take one more crack at the people to try to see if we can resolve this case at this stage. So for another probable cause conference date.
July 23rd, 2026, 9 a.m. bond continues.
Perfect.
Doesn't want to go to the detective. Nothing. That's it. The whole thing. It's just that comment was not directed at you, Mr. Bull. Where'd you know what? Court calls case Feeble versus Roderick Jacobs. Roderick Jacobs. Thank you.
And Your Honor, we're seeking adjournment for the negotiations.
July 23rd, 2026, 9 a.m.
Thank you, Your Honor.
You gotta make a decision. Court calls the case, People versus Darius Jones.
Assistant Public Defender, Canteria Cummings, Your Honor, on behalf of Mr. Darius Jones. Mr. Jones, when you reach the podium, state your name for the record.
Darius Jones. Thank you.
Your Honor, we're asking for an adjournment. We're still in negotiations with the people in regards to this matter. We'd also like to address bond.
We'll adjourn it. How much time did you?
Bond judge.
Hmm?
Can we address bond? I'm sorry.
You want to address bond?
Yes, please, Judge.
He's out.
I know.
Should go south fast.
Judge Mr. Jones is currently on a home confinement tether. He is asking that the court remove tether. Mr. Jones has an injury to his hand that he suffered last year. They had to put a stent in his left arm. He has a number of doctor's appointments. He's had to move a few of them to Zoom because it was just difficult to navigate the appointment with the tech and requesting the time off. Some of them he does have to go in person. They're doing a lot of stuff on his hand because according to his mom.
I will prepare an order. I'll allow him to attend medical treatment while he's on the tether.
Okay, just the out time. He is wanting to look for work too. He's 19 years old. He states that I can add that in the order as well if the court would like.
Yeah, well, but then the home confinement, he'll just say he's out looking for work. Most applications are online, so I'm not sure why he would have to be out.
And I guess primarily we were just trying to see if it was possible to at least just make it a GPS tether.
Not looking at everyone else, but it's relevant. Consider when the defendant made contact with Deputy Nito, he was disorderly in the backseat of the patrol car. He attempted to kick out the back window. He began attempting to kick out the back window of the patrol car by kicking, refused multiple orders to stop. Continued to try to damage the window. Attempted to put his foot away to prevent the back door from shutting. After being advised he was starting an investigation, his behavior did not change and continued to demand for the police to let his brother go. So I'm very concerned about this ability to remain long time. I do think the home confinement time is appropriate for the service.
I will only sign an order.
The Assistant Public Defender, Zach Vinny, with on behalf of Ms. Jones.
No, we say your name again.
Olivia Jones.
All right, who's that?
Your Honor, we're seeking an adjournment for the negotiation.
July 23rd, 2026, 9 a.m. Bond condition.
Thank you, Your Honor.
Thank you. Court calls case People versus Matthew McLean.
Stephanie Canna on behalf of Mr. McLean. Please state your name for the record.
Matthew McLean.
If you must, yes.
directly contacted the victim, but I have come to find a few jail calls that concern me and what she's telling his family members. Tell her that he loves her, as well as also mention to those specific family members who he's trying to get to be in contact with the victim, that if she does not show up, that the case would be dismissed, and suggesting things of that nature to them as well. So I have concerns, given that at first it's just to reach out with my love yous, but then it's also, so this time I'm going to be asking that the defendant be remanded, and that text privileges in the jail where you want to give it.
And Your Honor, in response to that, there's been no evidence presented whatsoever that any information has been communicated to the complaining witness in this case, communication whatsoever. She has been on repeat calling his family, and there'll be evidence of that if we do proceed further, trying to see what she can do to get the case dismissed. And that's evidence that we are going to be presenting to the court, and her taking culpability for the incident as it happened. I understand the prosecutor's position. And my client since then has not made any communication, reached out any way, shape, or form. Matter of fact, when he came in, because she has stopped communicating with her family and his family, he wanted to know if it was okay to call to get a welfare check on her, because he knows her mental health status and her drinking status. Your Honor, my client has, as soon as he got out, he went and checked himself. He went into the Don Farms outpatient program, and challenges with sobriety. So as soon as he got out, he came in and told me this is what he was doing. And I told him that's really good.
I have an official letter.
And so he is trying to fix this and straighten it out. He is aware that he cannot communicate with her directly.
Repeated indirect calls. As I indicated to counsel, and you're telling them in essence to communicate certain things to this person. So what I'm going to do is I'm going to adjourn the probable cause conference to.
Oh, Your Honor, we were asking for the exam to be set.
Okay, then it won't be, otherwise I'd give you a week, the 16th, your choice.
The 16th, Your Honor, we'll take the 16th, Your Honor.
I'll adjourn probable cause conference to July 16th, 2026, 9 a.m. At this point, given what the court has heard, defendant's bond is ordered revoked, defendant's remanded.
Good afternoon, Your Honor. Mr. Robinson's case.
A while ago, yeah.
Yes, told. Feaster just came and like pulled rank on me, Judge. It was scary.
Look surprised.
Yeah, I am. I'm shocked. So, Judge, if you can remember, Mr. Robinson was the young man who was in Winnebago. I have spoken to them.
Is where?
Winnebago. He is no longer in Winnebago. They informed me that he was transferred to Cook County, and he then called and said he had been released from Cook County, but is still in Illinois. He should have been on Zoom. We've spoken.
So he's in Illinois?
Please, Judge. Thank you so much, Your Honor. Really appreciate
it. Your fault. You're making me a nicer person. All right. They let us know that. What I'm going to do is I'll adjourn the probable cause of this out 2 weeks to the 23rd. Sir, you've got an orange shirt on. I need you to unmute. Tell me who you are.
Marise Robinson.
There it is. Mr. Robinson. Set this matter for a preliminary examination.
Discovery is complete.
To our knowledge, Judge, yes.
We'll have their witnesses available the 21st. Preliminary examination will be set in person. Bench warrant will issue for
verbally.
Appear bond 10,000.
Thank you, Your Honor.
What? What you?
Your Honor.
What?
So thank you so much. Oh, I forgot to say P76996. I keep forgetting to say my P number. I got to practice it because I keep forgetting it.
8? I'm still at the 8. 8.
I'll do my best.
I had already gotten my advisor to tell me that I should put it in the next block.
Thank you.
I was shocked by your answer, but whatever. Is that it? been a long drawn out first block.
Zoom, Mr. Bondi, if you can unmute yourself and say your name for the record.
Tyler Bondi.
And he's waiving.
Yes, Your Honor.
Mr. Bondi, you're waiving your right to a preliminary examination. Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Yes, Your Honor.
Your client stands mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
At 1:30 with Judge Slay.
August 27th, 2026, 1:30, Judge Slay. Bond will continue.
Thank you, Your Honor.
All right,
Thank you,
thank you.
Judge. Thank you very much.
More for the AG or no?
I also have Aaron Godfrey.
Case People versus Erin Godfrey. All right, do you have that one also?
Oh, yes. Oh, I didn't realize the appearance was entered for the prosecutor. Asli Bashir on behalf of Aaron Godfrey.
Mr. Wood for the people.
All right. And he is also waiving. So
Yes.
is that correct? You're waiving your right to a preliminary examination?
Yes, sir.
And you do understand that that's a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you haven't been waived? Defendant is bound over to circuit court on both counts.
Yes, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to both counts. Pretrial will be set for
Second at 1:30 with Joan Conlon.
September 2nd, 2026, 1:30 before Judge Conlon.
Perfect, Your Honor. Thank you very much. I appreciate you.
Thank you. Take care.
Thanks, Judge. You too as well.
Mr. Godfrey, you can log off.
Court calls the case, People versus Curtis Jackson.
And just make sure that you're visible on screen.
Curtis Jackson.
Thank you. Your Honor, at this time, to my knowledge, discovery is complete. We're seeking to request a preliminary exam be set.
People have their witnesses available the 21st.
Your Honor.
Preliminary examination, July 21st, 2026.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Mary Bagwell.
Your Honor, we unfortunately don't seem to have a client with us today. I can't give the court any further information about his whereabouts, but I would ask the court to consider an adjournment matter.
Ditto.
Legal term of ditto. Bench warrants will issue for the defendant's failure to appear. Bond in each of these cases set the amount of $25,000 cash surety. He does have a community corrections violation.
Thank you very much, Judge.
Court does call the case of the People versus Michelle Schaffner.
Christina Costantino appearing on behalf of Ms. Schaffner. Ms. Schaffner, can you please unmute and state your name for the court?
Michelle Schaffner.
All right.
I'm here.
Yes, I need a camera if you would, please.
Yes, we are, Judge. There's still some outstanding discovery. The prosecution and I have had multiple conversations about this. They're aware of what's missing, and it's my understanding Mr. Cook has made some good faith efforts to get that, and we should have that very soon. So we would be asking for an adjournment of the PCC.
Probable cause conference will be adjourned to July 28th, 2026, 9 a.m. That's a Tuesday.
A Tuesday. Okay. All right, Judge. That works for me.
Bond. Yeah.
Okay, thank you.
Thank you. Court calls the case, People versus Kenyatta Johnson.
Kenyatta Johnson. Attorney
All
Kennedy.
right. You're seeking an adjournment?
For the reasons that she said.
Okay. I'll adjourn the probable cause conference to July 23rd, 2020.
During the previous case, the court adjourned the 28th as the co-defendant on this case. We get them.
Got it. Okay. I'll do the 28th.
Thank you.
Thank you.
Bond continued. Court calls the case, People versus Taisha Morgan.
Good afternoon, Your Honor.
Good afternoon, Your Honor. Christina Saxon from Ms. Morgan.
What are we doing?
Your Honor, may we set this for a preliminary exam?
Discovery is complete.
To my knowledge.
Okay, thank you.
Thank you.
Thank you, Your Honor.
Court does call the case. Garrett Brown.
Garrett Brown.
All right, what are we doing?
I'm asking for an adjourned PCC. There was some discovery just presented. If we could have a couple of weeks, please.
Probable cause conference will be adjourned to July 23rd, 2026 night.
Thank you.
Bond continue. Thank you. Court calls the case, People versus Matthew Nabosny.
Matthew Nabosny.
All right, what are we doing?
Same request, Your Honor. I've been talking to Ms. Dover. We've made a plea proposal. I understand they need some time to talk to the officers involved in the case.
Probable cause conference will be adjourned July 23rd, 2026.
Good afternoon, Your Honor. Deborah Schlossel on behalf of the defendant, Mr. Quintez Coates. Mr. Coates, please state your name.
Quintez Coates.
Thank you.
Your Honor, at this time, I am new to the case, so I would respectfully request that this matter be set out a few weeks so that I can obtain discovery and engage in plea negotiations.
Adjourn the matter to July 23rd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Travis Higgins.
Good afternoon, Your Honor. Nick Sarnato requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Ashley.
That in the amount of $50,000 cash surety.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Gregory Huff.
And then we have to be Your Honor.
Good afternoon, Your Honor. May it please the court, Dwayne Johnson, P 41842, on behalf.
What are we doing on this today?
Your Honor, we're asking for a preliminary examination. I was looking at the dates you were given, and that week is pretty busy. Is it possible it could be scheduled for the following week, the 27th or the 30th?
It would have to be the 28th. We do them on Tuesday.
Who is the alleged victim in this case? It's supposed to have surgery tomorrow, and we were wondering, is he able to go to the hospital to just be of comfort to her or to be there present for that if she has the surgery?
According to his bond conditions, that would be a no.
Okay.
Would the people have their witnesses available the 28th?
We'll drop it, sure.
All right. Preliminary examination will be set in person July 28th, 2026, 12 noon. That's before me.
All right. Thank you, Your Honor.
Thank you.
It's going to be resolved in 2 weeks.
Probable cause conference will be adjourned July 23rd, 2026, 9 a.m. Bond continued.
Thank you very much, Your Honor. Have a great day.
You do the same. Court calls the case, People.
Time I anticipate that we will have a no contest plea. We're asking for an adjournment for 2 weeks. However, I know that the policy is I have to prepare that ahead of time and submit all the documentation to the court. So I will assure the court, if Your Honor adjourns this to July 23rd, I will have. Thank you, Your Honor.
Thank you, Your Honor.
We are all set.
Court calls the case, People versus Alfred Wright. State your name again, please, sir.
My name is Alfred Wright.
Thank you. All right, what are we doing?
Judge, we've been in talks with the prosecution. We have all the discovery that they have. So we just want to set it for a preliminary exam, please. Just to be honest, Judge, as I said last week on a different case when we were setting a different exam, I am booking exams in August. I don't have any other available dates.
I think we set your other one to the 11th.
Correct.
All right.
Thank you, Judge.
Take care. Court calls the case, People versus Javian Lovelace. Defendant having not appeared, a bench warrant will issue for his failure to appear. Bond will be set in about a $10,000 cash surety. Case versus Ebony.
We're still in negotiations with the people.
You don't have a green sheet. Probable cause conference will be adjourned August 2020. Bond kids.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, man. Court calls the case, People versus Cody Murray.
Anticipate being able to resolve this matter.
Probable cause conference will be adjourned July 23rd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir. Thank you. Court calls the case, People versus.
Ashley Bashir on behalf of Aja Nelson Chambers.
Aja Nelson Chambers.
Thank you. And Your Honor, I submitted a green sheet. We are requesting a brief adjournment of this matter, just for further negotiations.
All right. Turn the matter to the 23rd, July 23rd, 2026, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Thanks.
Bond continued. Court calls the case of the People versus Bela. Is it Yang?
He had his tether cut off by the Franklin County Jail. Mr. Yang is 20 years old. He lives in Columbus, Ohio. I contacted him on Monday. We've spoken every day this week. He understands he was supposed to be here in person. He tried his best to get here. He doesn't have a car. He is going to attempt to get transportation so that he can come up here next week, Wednesday, and walk in on the warrant and has to be placed back on the tether. So he does understand that there is currently no bond. I guess he's just asking that if he were to come back up here and walk, that he be placed back on tether.
Well, I'm not negotiating with somebody who's got a bench warrant.
Okay, understood, Your Honor.
So I'm going to leave the bench warrant out. I'm not setting a new date. He needs to get himself up. He's got a no bond warrant. If he gets picked up, he gets picked up.
No.
It's hanging out at the house right now. It's stuffed. Oh, God.
I feel like I missed the whole. Yes, you did.
All right. 14th County District Court for County.
Afternoon, Your Honor. William Amadeus, P76194 for Mr. Salisbury, who was granted permission to appear via Zoom. Mr. Salisbury, please state your name for the court.
Louis Salisbury.
Judge, I was appointed on this yesterday. I asked for a 2-week adjournment just to gather the stuff. Peter Feltus told me there is a warrant for him from Community Corrections. I was just put on this case yesterday. So I guess you dismissed the warrant.
Okay, there's a warrant out. Defendant will be pleading no contest to possession of a loaded firearm in a motor vehicle, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the
That is our understanding of the offer as well.
vehicle. That is a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that, sir?
Yes, sir.
About it, I have to make sure you understand it. First of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. Okay, so you're pleading no contest?
Yes, sir.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yeah.
All right. Do you have any questions regarding any of those rights? Are you on probation?
No.
Are you on parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will? Report the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you, between the time of me accepting your plea and the time of sentencing, if you commit misconduct as defined by the Michigan.
Yes, Your Honor.
The court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered at 1482 probation. Sentencing will be.
So, and this is a 4 case.
So I am.
Oh, it's a 4. I'm sorry.
Ask you for an adjournment. We received discovery late yesterday afternoon. I didn't have a chance to review it. So just need a brief adjournment for that purpose.
July 23rd, 2026, 9 a.m. Bond continued.
Thanks, Judge.
Thank you. Court calls versus Jeffrey Stoops.
We'll make sure he wears full-length pants at the next judge.
Got it properly attired. I just don't think that's it. But go ahead.
We are asking for an adjournment today, Your Honor.
You lost it? You don't have it?
Yeah.
Mr. Allen's was looking for it.
Dang. Wait.
2 weeks be enough time, Ms. Eikert?
I think it should be, Judge.
All right, I'll adjourn the matter July 23rd, 2026, 9 a.m. Bond continued.
Judge.
And I'll have the proper attire, sir.
Jenny. Thank you.
Okay.
You
can.
Court calls the case Feeble versus Joel Stevens. Judge Moore.
Thank you.
Thank you. Bye. Court calls the case Feeble. You're welcome, sir. Court calls the case Feeble versus Justin Thomas.
Justin Thomas.
You got him.
Your Honor, I am also asking for an adjournment in this matter. Mr. Thomas is working with my office's AIM division.
I'll adjourn this matter to July 28th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Court calls the case People versus Jessica Wilson.
So now it's people you're in.
Asli Bashir on behalf of Jessica Wilson.
Jessica Wilson.
And Your Honor, we are requesting an adjournment for further negotiations.
Court calls the case People versus Jessica Wilson.
So now it's people you're in.
Asli Bashir on behalf of Jessica Wilson.
Jessica Wilson.
And Your Honor, we are requesting an adjournment for further negotiations.
July 23rd, 2026, 9 a.m.
Your Honor.
Bond continued.
Thank you.
Court does call the case People versus Tony Woods.
Good afternoon, Your Honor.
President.
Amy Lucas on behalf of Tony Woods. State your name.
Tony Woods. Mr. Woods, I need a camera, please. Oh, I'm sorry. Again for me. Tony Woods. Okay, we got it.
We're seeking to adjourn the matter out 30 days as he is currently in treatment and doesn't have a release date until about September.
Adjourn it to August 13th, 2026.
Thank you.
9 a.m. without objection. Thank you, sir. Thank you. Yeah, that's it for you guys. That's it for us until 3. All right, court stands in recess. Pause. Court does call the people, case of the people versus none. Where is she? Please, thank you. People have put their appearance on the record. Well, you may go ahead.
Yes, okay. Good afternoon, Your Honor. Robin McCoy on behalf of Mr. Malakai Nunn, who stands to my right, P63057. I know when I was last here, I did not have the discovery. I did receive the discovery, the paper discovery. I reviewed all of the paper discovery. I would note that there is reference to a video, which my understanding from Madam Prosecutor is that they're working on getting video. As I said in my motion, Mr. Nunn, and I've known him actually all of his life. His mother worked in our office for about 10 years. His father is here. He has 2 sisters here, a girlfriend, and I think it's a cousin that's here. He is gainfully employed, and he has an apartment. He has no prior record, no juvenile record, nothing of the evidence from the video, which we don't have here today, which they referenced some things happening on a video that they went and got a search warrant. And so then that would lead me to believe, again, I don't have the video, that there might be some issues with the search warrant. And then all that was found was the fruit of the poisonous tree. If it's invalid questioning, he's not Mirandized.
Okay, but what bearing does that have on his bond?
Well, I would say this. They reference certain things in the police report as a means to refute the bond. And I was not at the arraignment. I understand that the bond was set at $100,000. As I said, he has no, I would say we'd have a tether, let him go to work, go to grocery store, go to doctor's appointments. I did talk to Reverend Green, and he said that he would work with him and talk with some of the other. I talked to Pastor Harold Wimberly, who review the police report. I would say this too. This is not a situation. I'm not going to name the names that are in there, but they basically are talking about other people that are involved with certain activity and pictures of other people that are not him involved with activity that's.
I still got an answer to my question. You're saying there are internal discrepancies?
He says that when the police came, he said he had worked a full day at his job, and we can get documentation to substantiate that, and that he came out to his car to get his charger, and he was let into his apartment and did certain things that he was not aware of, and that there's allegations that the items that were found in the apartment were involved with other offenses, which again, he has nothing to do with, has no knowledge of any of that.
Who are you saying has access to his apartment?
On the lease at the time, it's him and his girlfriend that are residing in the apartment. So it's the way the report is written is he's the only one that lives there. But at the time, it was himself and his girlfriend.
I mean, am I to take then from your argument that as to what was located in the apartment, certainly during this process, you can challenge it, but he's saying that wasn't his.
Correct.
And that
what's referenced in the report is that there was some kind of shooting shooting and she was at the hospital. He said he went to visit her at the hospital. She was pregnant at the time. He says that she had baby clothes in her car and she wanted him to take the baby clothes. He took the baby clothes and then he went to his apartment. And then he said she was still upset and that she comes over there to meet him at the apartment and he's trying to calm her down and she's upset about the situation. But he believes that his girlfriend let her boyfriend in and that it's the boyfriend's items that were found in the apartment, not his.
And it was who?
The boyfriend, Sierra's boyfriend.
Anything else?
Again, I would just say I've known him all his life. I've never known anything like this. He did graduate from Ypsilanti High School. He's had a pretty solid work history. He worked before. I know he worked at the Noodles Company. Everybody is very obviously distraught. He's never had anything like this. He's upset about this because he's like, this is not me. He has assured me that this is an experience. He will not associate with the people he associated with before. He said this is one and done. And he's willing to take a lie detector tests as well. So I'll just put that out there.
Guys, tangentially involved in shooting. The defendant lied several times. He went by the hospital, did not stop his car, did not get out, did not find who he was looking for and left. Then when he was pushed back by the officer who mentioned surveillance footage, he said he stopped for a minute, looked around, still didn't see her, and then left. Now today, he's telling a story where he did stop, he did find the vehicle, he did find who he was looking for. He was moving stuff back and forth between the vehicle that was involved in the shooting. Yeah, this is just a deep.
And Your Honor, if I may respond again, I wasn't there. The prosecutor wasn't there. This police report was written up. This is my second time talking with my client about the situation. There has been, from my standpoint, consistency where he was saying that his friend called him in distress. He had no intentions of being dishonest with the police. He had no idea what was in his apartment. And he said that he has had some bad experience in the past with the police. So he did obviously, I think a lot of folks have PTSD, anxiety when it comes to the police. So.
Were he tied to what was found in the apartment? That makes him a danger to the community.
I would acknowledge that, yes.
And so I've got to then go on some limb to find that to those items belonging to someone else.
Well, in the report, though, it does say that the items belong to Davon, to someone else. It doesn't say that the items belong to him.
I know.
It just says the items are found in his apartment.
But they're involved in if I have two people in an apartment, then are you saying that it's the girlfriend? I mean,
we're not saying it's the girlfriend. We're saying what we believe is. I would say that we would need to talk to the girlfriend to see what her statement would be, and also talk to Sierra about what happened at the hospital. So, but I would say again, Your Honor, I understand you. That's why we're saying if you put him on a tether, then we will know where he is. He's got to go to work.
It isn't the question of necessarily knowing where he is, although that becomes an issue. It becomes an issue of an assessment of this individual's threat can give then one assessment to those items being in that apartment. But if the defendant, but I don't, the part that would favor you would be if there's some indication that
right,
you acknowledge that if those items are tied to him, that he would be a danger to the public.
I would not say again, I wasn't there. I would say if
McCoy, you could try to sidestep it all you want.
No, I Your Honor, I just want to make sure I'm clarifying for the record that are a danger to society. And the allegation against him is that he lied about what happened, lied about his apartment, lied about what happened at the hospital, and that there were items found in his apartment connected to what the other individuals did. And there's pictures and there's all
Individual, how should I say, participates in a cover-up of those crimes.
right.
Would you consider that person then to be a danger?
I would consider it definitely would be a problem. They're young, they're dumb. They shouldn't be, if they're an eagle, they shouldn't be hanging with the chickens because the chickens will bring you down. I would say that. He's 21, no prior record.
I realize there's some very dangerous and tragic things that have occurred. And he has in his possession, it really becomes an assessment of how dangerous then is this individual.
Like this, I'm not gonna do it anymore.
Dangerous.
Well, I would say he's 21. The adult brain doesn't fully mature till the age of 26. Some people would say 30s for some folks. He has a job. He has to get caught up with the situation. Even
Ms. McCoy, where would he stay if I were to release him?
if you were to release him, he could go back to his apartment, or if the court is saying, no, you're not going back there, he could stay with his parents, and they live in Ypsilanti, which I can give. He has a sister that's in college in Detroit. He has another sister that lives in Columbus, Ohio.
So where would he, in your...
His mom, I talked to his mom. She said that he could stay with her and his father at their residence.
Yes.
Might briefly approach.
Okay.
Good afternoon, Your Honor. Nicole Sadi. I represent Ms. Henderson, and she is now at the podium to my right.
Okay.
Nicole Henderson.
All right. I've received the assessment. Have the parties?
These recommendations Scatman are making include abstinence as well as outpatient treatment. I'm also looking at the law enforcement bond information form that I'm showing Mr. Cook right now. Thank you. Let the record reflect I showed it to him. Looks as my client is willing to wear the tether as she understands this is normally a usual part of bond on a matter like this, as well as engage in AA. I understand that upon reading this report, it may put to somebody's mind, well, Ms. Henderson has been to rehab before, that she would be a good candidate to go ahead and receive outpatient treatment combined with these other recommendations.
You're having just two brief things. One, just a slight correction from what was just indicated about the information form. Where I believe the counsel looking, that was the first paragraph indicates that the defendant completed field sobriety. She was only able to complete one of the three tests, to my understanding. The other two were not conducted or completed due to the defendant's lack of cooperation at that point. Admittedly, as the court's aware, she was incredibly intoxicated, so I'll just attribute that to her recollection. The event might not be the best. I don't think there was any malice on her part, but I think it's important for the court to have that corrected understanding.
I would like to respond. I will say that this is while Ms. Henderson acknowledges what the blood draw was, this blood draw was taken well over 4 hours after the initial arrest where blood alcohol rises. So it is not an indication of where her level was at the time of arrest.
So we're going to argue over those points?
Your Honor, in the bond argument we're making based on this report, I'm bringing forward based on science for my client to pursue.
Why do you think I asked?
I'm not in your mind, but you said that you were concerned about my client's health You're concerned about my client's mental health. You're concerned about her relationship with substances. And I believe you ordered the assessment because you wanted to be informed on those concerns before considering reducing bond. That's my belief.
Why can't I get arguments that go toward that? Because I've been trying to get Miss Henderson out. I've been trying to do it in a safe way. Gonna get none. So go ahead.
Your Honor, that is extremely unfair. And on the record last time, you said something that was unfair as well.
You know what? This ain't about you.
That's right.
This isn't about you.
That's
It's
right.
not about you.
That is correct.
Stop right now. Deputy, take her back into lockup court. What I'm going to do is defendant's going to be released on a personal recognizance, $25,000 bond. Prior to release, she must be placed on a scram tether. You're programming through, because you're employed with GM, right?
Yes.
And so I'm going to indicate also that the defendant is to engage with, is that GM or UAW program?
Well, it's called River Spin.
Finding the defendant incompetent, the court will grant that motion. I have reviewed the independent competency report, find it persuasive. Counsel has waived a hearing with testimony on that case, and both parties have stipulated to that report. Therefore, the court would then find that the defendant is competent to stand trial.
Thank you.
All right, counsel, I would need you, part of that, I need an order that your motion to reconsider is granted.
Gotcha.
So those two things.
Thank you, Your Honor.
Next.
Your Honor, the court did give us a chambers conference earlier today, and we had a very productive conversation as to the issue of bond. When we were here last week, we discussed the defendant going for walks and the people's stipulation to the same, the defendant not be allowed to go. It's my understanding, and I'll let defense counsel speak for herself in just a moment, that that's just not practicable for community corrections. So instead, defense counsel and I were exchanging emails about locations he could go, and I'll let her make her record for.
Client could go and exercise. They have access to a car, so they can drive to locations like VR.
Ones that people have no opposition to.
All right.
Would be the Botanical Gardens, Trinkley Marsh at Easton Farms Preserve off of Dancer Road, Nichols Arboretum, the Ingalls Mall location near Burton Tower and the Michigan League, and the Broadway Bridge near the Huron River. They're working to and would object to. The first would be the Ben & Jerry's ice cream store on State Street and the Natural History Museum at the University of Michigan. You know, the concern of the people with those two locations, especially the Natural History Museum, the presence of children during the summer months, especially doing school trips and also during the school year doing sort of field trips, and the large amount of children that can be at those locations. So we would not agree to those two locations, but would stipulate to the remaining 5 that we've indicated.
And one of the questions
Defendant was engaged in in the underlying case at an elementary school, which of course is a location that does contain a large number of children. So that is the concern of the people with those two locations specifically.
understood. All right. Yes. And
Nothing to add, Your Honor.
will allow those locations. I would agree with the people regarding the museum and will not allow that. The difficulty, not because I like Ben & Jerry's ice cream, but the difficulty for the Ben & Jerry's ice cream is certainly there may be kids there, but I don't see it as B2 I will allow.
Thank you, Your Honor. The next.
Just so that we're clear, it's still a home confinement tether.
Judge that is related to his bond conditions.
Yes.
I wanted to move that this court allow to return to his home address on Duncan Street. School is now out of session, Your Honor, and I understand the proximity to the elementary school. And I understand that, but he has been for the past 6 months in compliance with all of the court's conditions. He has been confined and unable to even go out, and he has had a very difficult time with that, Your Honor, and for him moving back home. Thank you.
Yeah, for the record, the people are opposed to that change in bond.
The people do believe that it is not an appropriate change at this time. We would ask that the court does not allow the defendant to return home. I know the court's aware, but for the record, there was a prior incident in October of 2025 involving the defendant and a teacher at the school being on the school property while children, I understand, were playing outside, involving a potential threat. That did not result in any charges. But then we do have this extra incident that happens that does result in charges in January of 2026, where the defendant was remaining at his house at that time. He had lived in the house for both of those incidents for in court to speak with a teacher who works at Hazley Elementary School, and she's assured me that she feels confident in speaking for the teachers at that location, and they would also oppose any change in bond to allow him to go back to the home, as well as I've had the opportunity to speak with a parent of a Hazley Elementary School child, and she's informed me that she feels confident that she could speak for the parents, and the parents of these children would also oppose the change to allow him to go back home. I understand that there are concerns about share with the court what I understand the concerns to be, that there's concerns with feeling safe sending children to the school by the parents, given the nature of the threats, concerns that the children would not be safe if he was at his home because of the proximity, should he choose to what they're doing due to the nature of this incident. She shared with me that previously, after the incident happened in January until the end of the school year, it was distracting and it was disruptive when anybody would walk outside the school in the outside area, and had a lot of concern and fear. Other people walking outside created a lot of concern and distraction because of this, because of the fear around this incident.
Okay.
If the court does intend to make a change to the bond to allow the defendant to return to the home off of Duncan, the people would respectfully request a delay in that happening, not having it happen today, not having it happen for a couple of days, but to allow some sufficient time to get information out about safety planning, any type of parameters that would be applicable, and anything else to allow information.
But I'm also clear, we had discussed in the bench conference that the staff returns on the 10th of August.
That is my understanding.
All right. And also, I'm a bit, well, I'm not unclear, but the prior incident that you're talking about was an incident where the defendant was on a bike. We're dealing with somebody who suffers from autism to a certain degree, and then with some other issues. And my understanding is in that incident that the defendant was stopped by the individual, or I guess what I'm trying to figure out is he had not previous to that point in time been trespassed.
Correct.
He had not.
Talking about the October date, Your Honor. Yes.
Yeah.
Oh, very good. Thank you.
And also, I guess, put it this way, was there authority to deny him access to the property?
I can check really quickly, Your Honor, but I'll correct this if it's incorrect. My understanding was he was on the school property when the children were outside. So the
court, he was not he is 18 years old and does not go to Hazley Elementary School. And so he, while school was in session, did not have the authority to be.
That's correct, Your Honor. I understand there's signage that indicates that the school grounds are closed during the school day, And when he came down the path on the school day, a teacher confronted him and said, hey, you can't be here. And that's when there was the statement about the gun. And subsequent to that, a detective did trespass him. An Ann Arbor police detective, is my understanding, trespassed him from being able to go back to Hazley.
Okay. So there's signage.
And I haven't seen the signage, Your Honor.
No, I understand. And I guess I would be curious, and I just aren't aware of the authority for the signage for that.
I would have to check, but
Okay.
it would make logical sense to the people that Ann Arbor Public Schools could close their campuses during the school day for people that aren't students or parents or teachers to have access without prior authority or going through a visitor process. When I visited elementary schools, I've had to go through a visitor.
The question I have is to what extent that extends to the grounds.
Very good.
Because I can think of a few schools where that almost becomes an impossibility because they're neighborhood schools. And if one, I guess from there, if one wanted to traverse, say, to Maple Road, certainly you go up to Miller and then go down. But depending on where you were going.
Not having a good answer on that right now for you, Your Honor. I can get an answer about the authority for the signage and all of that. It's not something I have in this moment, but I'm happy to work on that.
And just one more question regarding an incident, that the interaction occurs without the intervention of the police. Is that right?
The initial October interaction, at the time, yes, the interaction occurs. And I think police contact happens later. I don't think it happens in the moment.
All right.
Anything else? No. Thank you, Your Honor.
I may offer two things. One would be just as a counterpoint to what's been presented to you. I have many letters from neighbors that have known Mr. Calhoun for his growing up, and many of them going back to the neighborhood. I have several letters. I could provide them to the court. They're just in electronic form right now, but I could get those to the court if the court is interested in seeing them. And second, Judge, I understand the teachers' concerns about the school. The house itself, the back of the house and the sort of garage structure abuts the property of the school. But if the court would allow, we could fashion very restrictive conditions so that even, he has to exit from the front of the house and turn to the right to avoid the school. We could have exclusion zones set from his back porch of that house up to the property line and through the, school's property. I'm just trying to find a solution here, Judge, that would allow him to be at his home, which I believe would be very important for his mental health, for us proceeding on this case. He has again complied with 6 months of the court's very serious restrictions and done it successfully.
And Your Honor, I wanted to correct one thing to make sure. The interaction between the defendant and the teacher didn't involve the police, but the police were contacted that day. I wanted to make sure that was clear for the court.
Yeah, I thought you had answered the court's question that they see this individual. And do we have the date of that interaction?
October the 6th.
October 6th. So somebody could get to the court. I don't know whether, the officer, I would suspect, would have, if he were trespassed, read a report or written even a simple report or a citizen interaction. He was trespassed and then without further incident, theoretically off of that.
Until January.
Until January.
Yes.
All right. From the south side of the Duncan entrance to Hazley. Mr. Calhoun's home is 3 houses down, is that right?
I have a map if the court wanted to see it, but it is, I can tell you, spot here. Like I have one of those line drawing maps.
Anything else on this issue?
Nothing further. Thank you, Your Honor. Thank you.
All right. Part of the courts, so there is the other issue that my understanding is that there are now 3 people in the studio apartment. No air. They're there. Some of that's going to be resolved with the teachers returned. I'm gonna do, in effect, what is an interim order that will last for a period in time, and then the court will hear additional argument and then review it. A couple of things are going to change. Yeah, one thing that will change is the GPS enter the home and then to leave the home through the front of the premises. And then from the front of the premises, he must make a right out of the front of the premises. What that does is that prevents the defendant from passing by the entrance from the neighborhoods there, that the property of Hazley School is fenced. I'm going to set a hearing for October 6th, which will be
August 6th, Judge?
August, what did I say? Actively with those that are involved and may be affected. This order won't take place, or the ability to return will not happen until the 13th Monday, to allow communication to those that are involved. Anybody need clarification on what I've just ordered?
Your Honor, the house appears to sit facing east with the school
Yes.
behind it to the west, and entrance is south of the home. Did the court?
The entrance is south, correct?
Did the court want me to indicate the defendant could only turn right, or did it mean to indicate he could only turn left to go north away from the entrance?
I did have one question, Judge. It's just, would you like this to be the subject of a second order that's not combined with the order regarding bond conditions? So like there's the order regarding bond conditions regarding the walking, and then would you like a separate order for this sort of interim? Last thing is just to set another date.
Yes, and that will be August 6th, 2026 at, I'll set it at 9, but you'll get your time blocks on that. And I would just say this, that in a circumstance such as this, there's no one that is going to be on the information that it has. This court, and all the time I've been sitting on the bench, certainly